I'd like to do now is to give everybody a minute, maybe a minute and a half, if you'd just like to sum up and give a review of what you feel the key takeaways are. And I'd like to do it in the order of speaking sequence. So, Frank DeLucia, we'll start with you for some key takeaways.
Yeah, so from the patent owner's perspective, if you make a motion to amend, make sure you comply with the procedural requirements. You don't have to go for the burden of persuasion on patentability. And as we discussed, the burden is on the patent owner. The patent owner does need to comply with the burden of persuasion.
Thank you, Frank DeLucia. Matt Duszek, some key takeaways from you, please.
Yeah, my takeaways are very similar. It's a very significant change to have the burden of persuasion move from the patent owner to the petitioner. But that statistic that over, the AIA trials that have had motions to amend in the last, 6 years or so, some 60% of motions have been denied for reasons other than the patentability of the prior art under sections 102 and 103 really highlights that the patent owner still needs to pay careful attention to the procedural requirements, written description support, 112 issues, and what the claims mean.
And finally, Brian Murphy, some summation, some key takeaways from you, please, sir.
Well, just to repeat, I think the big takeaway is that under Director Iancu, the PTAB is reconsidering the entire motion to amend process from top to bottom, and they're clearly making significant changes, and I expect them to implement those changes in a rulemaking package probably later this year. And I think people should stay tuned and also look for some type of new process to make it easier for a patent owner to implement its proposed amendments.